that's the course code. Is for your class is Introduction to Law and Nigerian Legal System. And since we're in second semester, is number 2. And this course is also taken as Nigerian Legal System 2. So if you see it on any of our platform, or even the books that we refer you to, they are also can be titled Nigerian Legal System. Okay? So today being the first class, we are going to be looking at the course contents, or we are going to be dealing with in the course of this semester. And by way of information, is a continuation and an extension of the journey we started during the first semester. So this course in this second semester will open your eyes to the judicial system in Nigeria. Okay? To open your eyes, we create that general introduction to the judicial system in Nigeria. Also, it will provide or give you the basic knowledge about the history of the Nigerian judicial system. That is, how we have fared in our judicial system from when we began to recognize ourselves as a people to where we are now. Of course, you will believe that what we used to have in year 1960 is not the same system that we have as of today. As a matter of fact, some of the things we do now, some of them were not in existence at that time. So, of course, it also relates to our own judicial system as a nation. So, the course this semester will expose us to the history of Nigerian legal system, and then it will also lead us to critical discussion about how the judiciary functions. Okay? How the judiciary operates, the power setting up the judiciary, or the law setting up the judiciary. We will look at the roles and the function of the judiciary. And then we will be able to itemize these functions, these roles, and have a better understanding of the components of the Nigerian legal system. So that is all that we are going to be dealing with in the course of the semester. And we are going to be looking at, in order to do justice to these topics, what is it called, the summary that I've provided, we are going to look at 7 topics. Okay? All of that will be broken into topics 1 to 7. And of course, they are designed in a way to provide that logical sequence so that you can understand by the way they flow into each other. So the outline will include number 1. We will look at the role and function of the judiciary. What did I say? All right. And to delve into that discussion, Section 6 of the 1999 Constitution of the Federal Republic of Nigeria will be our foundation. Okay? So, in looking at the role, the function of the Nigerian legal system or of the judiciary, we will take our base from Section 6 of the Constitution of the Federal Republic of Nigeria. And then, under that, we will be able to see the difference between judicial function, judicial powers, and jurisdiction. What did I say? We'll be able to identify the distinction between judicial function, judicial powers, and jurisdiction, meaning that the lesson or the lecture will deal with what is judicial power. What are the functions of the judiciary, and then jurisdiction. You get to understand all of that. Now, I give you an example in order to prepare our mind to what we want to look at. In this class, it's very possible that there are two people that are fighting, right? They are quarreling. They used to be friends before, and now they are no longer friends. What are the likely cause of such disagreement? Class, where are the people that are quarreling now? They used to be friends before. Money. Okay? Yes. Well, no, I need people who are not. I want them to and okay, stand up. Because last semester, just like a joke, I was teaching in that other class. And I said, I have people quarreling with one another. And then, yes, one lady stood up, pointed the person. And indeed, it was a real quarrel. But thank God, one or the other were able to resolve that. But what we are saying is that in every society, there will be disputes between individuals. Dispute between government and either citizen or citizen towards government, or between individual to individual. And of course, when you look at the Yoruba adage that says, I own Ikorimaji, meaning that you really cannot do without having such conflicts, and then, of course, there will be need to resolve all of those issues. So, what do we do when issues like that, come up? So we rush to court, isn't it? When we rush to court, we believe that the court has the power to adjudicate on whatever is the issue between the parties. And then when the court gives judgment, it becomes what? Final. Let's look at when President Tinubu contested election. The likes of Obi, Atiku, where all of those were contestants in the election, isn't it? But when the election, came to an end, and President Tinubu was declared the winner, some people were not satisfied with the declaration. Right? And there are people like that in this class. Can you raise your hand? Okay. Some were happy that our candidate has won the election. And then, what are we going to do as a people? Every one of them did what? Went to the court. They went to the court because they believe that the judiciary has the power to do what? To resolve that dispute. It would have been that, okay, go to hell. They have declared me winner, I am going to Asolo. But what they went through the process, went to the court. At the end of the day, the court pronounced one person to be the duly elected president. And the rest people, what did they do? They had to do what? To accept it. But if I had said, in my capacity as a lecturer, I said, Mr. Tinubu is the winner, will they listen to me? Who will even hear my voice? Because only my students are so powerless that they cannot install whosoever I want to declare winner. But they recognize the power of the court to adjudicate on those issues and declare one person a winner. That is the power vested in them. They didn't go to the National Assembly. They went to what? The judiciary. And then the judiciary did some form of interpretation of the law, even to as to what the requirements must be before you can become the president, what you must do, what you must have attained, and so on and so forth. And the court took time to do what? To explain all of that. They discharge their function in the course of all of that. So, that is the things that we're going to be looking at by virtue of that topic. And then we'll look at topic number 2, which is that traditional system for dispute resolution. Traditional system for dispute resolution. In the course of the lecture for that topic, we will look at the sources of conflict in the indigenous African society. After we have looked at the introduction, we will look at sources of conflict in the indigenous African society. That is, those things that causes what? Disputes or conflict within the society. Of course, some of us already know some of those things. Can you mention them? Land. Yes, land. Are you fighting over land? Let's pray for you now so that you can win. Yes, land. Money. Chief transparency. Marriage. Yes. Religion. Yes. Yes. Child. What? Well, childbearing, inheritance, and so on and so forth. We will identify all of those things. Then we will look at the features of indigenous conflicts. Features of indigenous conflict resolution. I repeat that again. Features of indigenous conflict resolution. That is, the various characteristics of those conflicts and how they are resolved. Also, we will look at the characteristics of indigenous conflict resolution. The characteristics of indigenous conflict resolution. And then when we're talking about the characteristics of indigenous conflict resolution, we'll be looking at how the setup is. In those days, when there is an issue between two people, they usually go to either the Olori, right? They go to the family heads. In Igbo land, they have what they call them. Unai. They go to them, they resolve it. But in our contemporary time, people don't know any Olori again. The only time people get to talk about Olori is when they are traveling for land. So in the course of our study, we are going to explain all of those as it relates to indigenous African society. Mind you, the topic is traditional system for dispute resolution. Then under that topic also, we will look at the various institutions of conflict resolution in Africa. The different institutions, that is, the bodies that manages conflicts. You know, like those days, which is used to settle quarrel. You don't know? How many of you have been in which before that are involved in things like that? Nobody knows. the engagement of the Council of Chiefs, even the role the shrine plays in what? In conflict management. All of that, we are going to look at them one after the other. Then we will look at the traditional methods. The traditional methods of conflict resolution. The traditional method of conflict resolution, which will involve, number one, negotiation. It will involve mediation. It will involve arbitration. It will involve adjudication and reconciliation. Can I repeat those again? Number one, negotiation method, mediation method, arbitration method, adjudication method, and reconciliation method. Now, can I tell you something very interesting? Even though all of these methods can be traced to our indigenous system, our local system of dispute resolution, these things, this method form the foundation of the modern system that we practice today. When you look at Lagos State has a place they call multi-door courthouse. You know what they do there? They resolve disputes in an amicable way, where parties will sit down, they will sit and ask questions. So what is it? How can we resolve? It's different from when you get to court and as a lawyer you wear your wig and you are flowing grammar, using all the available laws and evidence to prove your case. But in Lagos State multi-door courthouse, you will be in a relaxed environment where you will hear from both parties with a mediator saying, why don't we go do it like this? Because sometimes, there's a saying, I'm trying to put the complete saying together, that when they be courts, right, and it's on the ground, you can never pick everything again. It's not possible. You cannot collect, because some will have worked. Except those stubborn, especially those stubborn ones that before they land, some of them they float outside. Meaning that when there is an issue, you probably not be able to have all you want. But in those traditional systems, they will say, "Oh, God, he stole your 10 tubers of yam. He has brought it. You will not back." And if you were worried or anybody, you say at all, 9 back, and you collect your 8, you say, is it even not better than Mr. Bonus, that he took his 22 and he did not even see anyone? But one way or the other, she has been pacified by the fact that she was able to get something. Those were the various systems that prevailed in the traditional African society, and that's what we have organized and that we are practicing today. And somebody will fly in from South Africa and will say it's an arbitrator and sit over a dispute resolution and earn dollars. And in those days, when these methods were originated, they probably used palm wine to pay the elders. Okay? But the reason why we have to look at them, those methods, is how the role they are playing to take our judicial system to where we are now, so that we can appreciate where we are coming from and also where we are at the moment. So after that topic 2, we'll look at topic 3, which is history of the Nigerian judicial or court system. History of the Nigerian judicial or court system. So when I say judicial system, I'm also referring to court system. Do you follow, class? All right. So look at history, and when we are looking at this history, we're going to divide the topic into 3. Okay? Meaning that we are going to look at the pre-colonial judicial system. The pre-colonial judicial system. We will look at the colonial system, that is the British colonial system, and lastly, we will look at the post-colonial. Those three segments are important because different things transpire in the course of those identified three stages. The pre-colonial was before the military came. When the military came, not military, sorry, the colonial masters. Our militaries are not coming. How they are not coming. Okay. So the pre-colonial era is the life we were living or the era before we were colonized. Like when we look at our dressing now, if we're in the colonial era, all these beautiful dresses will not be here. What are we going to be seeing? These are usually the dialogue. Yes, his sleeves will be seen. In those days, there was nothing like spaghetti or indomie. So what you'll be seeing is what is animal skin or leaf. Some people will even not be going as a wheel. But during the colonial period, what happened? In the area of what we are talking about, they introduced their own law, their system, small. And that was when they brought all these clothes to us. Right? That was when we got some of the things we are doing now. In those days, you had these people who dress half naked. But because we have taken over the white people's culture, people now take pride in dressing anyhow. And then, when we're talking about the post-colonial, it will be what our system has become after the colonial era. And of course, that covers the period that we are at this time. Number 4 topic will be structure of the court system in Nigeria. The structure of court system in Nigeria. How is our court structured? What kind of courts do we have? We are going to look at all of that in the course of topic number 4. Then we move to topic 5, which is meaning of courts and classification of courts. Meaning of courts and classification of courts. So that will be the topic for topic 5. And that particular topic will expose us to the meaning of courts. I'm talking about C-O-U-R-T-S, not the other one. Okay? Then the classification of courts. Under this topic, we'll look at the various classifications. Number 1, superior and inferior courts. We deal with superior and inferior court as one classification. We will deal with courts of record and non-courts of records. Courts of records and non-courts of records. That's number 2. Number 3 will be courts of limited and unlimited jurisdiction. Courts of limited and unlimited jurisdiction. We will also look at English and non-English courts. English and non-English courts. Another classification we look at under this topic is courts of original jurisdiction and courts of appellate jurisdiction. Courts of original jurisdiction and courts of appellate jurisdiction. Courts of original jurisdiction and courts of appellate jurisdiction. Also, we look at federal courts and state courts. Federal and state courts. And then we look at special courts. Special courts. So, all these are the various courts that we're going to look at. As you apply your mind to them, you begin to have understanding as to why we have to look at them in that form. And then, topic number 6 will be establishment, composition, and jurisdiction of Nigerian courts. Establishment, composition, and jurisdiction of Nigerian courts. Simply put, how did those courts or this court come into existence will be our focus under this court. Then again, what are the composition of this court? There are some courts where you have one judge, right? There are some courts where you have 5 justices. There are some courts also where you have about 7 justices presiding at the same time. Have you ever come across anything like that? Maybe most of the courts you have seen is where a judge, one person is what? Is the one doing the thing. But there are courts where 5 of them. If you are close to court of appeal, you are working any day, you see that 5 justices are sitting to listen to one person. And then when you now get to the Supreme Court, which is the highest court, we have about 7, sometimes 6, depending on the matter they are dealing with. The question then will be, why do we have the structure like that? I'm sure you'll be interested in knowing. You will get to know that under that particular topic. So, the courts that are under this topic 3 or topic 6 are number 1, customary and area courts. We'll look at their formation, their composition, and their jurisdiction. Now, in order to, put some more interest in you on this topic, when you have a land matter, it is not all any court you can take it to. That's why we talk about jurisdiction. You have heard of magistrate court before, right? You've heard of high court before. Have you heard of national industrial court before? You've not heard of it before. Have you heard of Sharia courts? Yes. Have you heard of the Supreme Court? Yes. What of Court of Appeal? Yes. Now, have you heard of Federal High Court before? Yes. Okay. Now, if you have a matter, a case, that's what you call case, you call it matter, that involves like 9 million naira, meaning that at the end of the day, if the court will need to award, so you were part of this class and you were standing there, looking at me. If you have a case where monetary involvement is like 9 million, the magistrate court can entertain it. That's because there is a limit. Any case that the monetary involvement is more than 10 million, the magistrate court cannot hear it. The magistrate court cannot hear cases that have to do with land. Okay? Land. But they can hear cases of landlord and tenant. The reasons are clear. Then I said National Industrial Court. Some of you say you have not heard before. That court deals with cases, labor cases, employment relations. Do you understand? They deal with such things. Then there are some courts, like the Federal High Court, deals with cases that has to do with maritime. That is the sea. Things that relate to the sea. Now you begin to wonder why the classification. There is reason behind all of those classifications. Those are the things that led to the formation or the classification of this court. If you want to deal with the issue of inheritance, which is kind of customary, there are courts that deals with it. We have a customary court. Each customary court will know the culture of a particular people, right? And then they are able to provide judgment that will suit the people who have come to it. Just the way we have different culture all over, we also expected to have different courts that should be able to administer justice as the need arises. So that is the reason why those courts are different. Because we will not be wondering, why are we looking at all these courts? I'm mentioning the every court that we have not seen before. It is because of the subject matter that they deal with. It is because of jurisdiction. For example, now if you want to divorce, it's not any court you can go to. You cannot go to magistrate court if you want to divorce. And then even if you must go to a particular court, there are conditions that you must meet. So that's why we're going to be looking at all of those compositions, the jurisdiction. We talked about their powers, what they can do, and what they cannot do. So I said customary and area courts. We're going to look at magistrate courts. I think that's the one you are so familiar with. I think one of the things you can do for yourself as you are taking this course is that just walk into any of those magistrate courts and see some of these things that we are saying. Okay? Just have a feel of, even if after you have finished this course and you now focus on your mass communication as a course, you can throw them away, but just have the knowledge. Because some of you will become landlords tomorrow, and then you have stubborn tenants like some stubborn people in this class, and how to drag them to court. Just even have an idea of where you take them to, so that if God forbid you come across a lawyer that is not a lawyer who is going to be a lawyer and is a dubious human being, and he will tell you, sir, this your case is very serious, so it's very serious, so this case, we are going to start from the Supreme Court. Because if we are going to start from the Supreme Court, we will spend money. You've never been to police station before. When they want to put a liar here, they want to make you to be afraid. Hey, this is that your son has done. They are just trying to work. But if you have an idea of all of these things, anything anybody says, you are also able. So the advantage of learning law or doing many things in your bad law is so much. So don't just stay saying that, let it just pass and move on. So we look at magistrate court, we look at state high court, national industrial court, we look at high court, federal high court. We also look at customary and Sharia courts of appeal. Customary and Sharia courts of appeal. Then we'll look at appeal courts. Appeal courts. And lastly, we'll look at the Supreme Court of Nigeria. The Supreme Court of, and what we'll be looking at on all of these courts is their composition, is their jurisdiction, and so on and so forth. Then the seventh topic is special courts. Special courts. Can anybody mention any special court that he or she knows? Juvenile courts. Yes.
Military courts. Military court.
Military court, yes.
Sharia court.
Sharia court, yes. What?
Administrative tribunals.
Administrative tribunals and what?
Corona.
Why? Yes, Corona. Why are they special courts? Because of their logo. Because of their name. Why are they special courts? Did you with criminal matters? Special matters. Okay, like what?
Like for instance,
This one is using sense for you. Special court, special matter. Ah, wow. It is sometimes you need to use sense. I like that. Let me give you an example of a colleague that used special sense for us. You know, they asked us to write 10 Latin maxims. 10 Latin maxims they are principles of law that originated from Latin law, so to speak. Let me simplify it like that. Number one is nemo that called non abet. You must have heard that before. That you cannot give what you do not have. Okay? It's a principle of equity. Number two, you can have something like S tolo mano no orito acho. Okay, let me stop there. What that means is that the court of law cannot be used to enforce illegality. If, for example, somebody is a prostitute, the man carried the woman, and prostitute is a crime. And then after you have done this something, you say the man did not pay you. Then you want to drag the man to court. The court will not help you to collect your money. Because what you have done is what? So after that, my friend has written 9. He made one. He don't know what to write. He just wrote request. That he now puts what will be. And you know, sometimes a lecturer will know this person has done 1, correct, 2, 3, 4, 5. You know you got seated. That's the sense of it for his book. Whatever I research where is put you into trouble. Alright, so because they deal with special matters, for example, juvenile courts, they deal with children. Because they believe that, we believe in our system that sometimes when children do some things, they do it because, locally speaking, that they don't have sense yet. You get that? And there are some behavior that are common to children. There are some that child delinquency, all of that. A child can just be unnecessarily angry and be breaking things. I saw one video of a child in one mall that was destroying, because he has not worked before. He does not know what it is to earn. He probably does not even know that thing costs money. So the law believes that such people should be treated specially in helping them to either know what they are doing or be corrected. Like, for example, also corona courts. Those are courts that inquire into cost of death. I mean, you heard of your brother Mohbad, right? The special court, corona court, was, to investigate what led to his death and all of that. So we are going to look at all of that. Military, they can't carry military matter and bring it to a popular place where everybody will be listening to what they are saying. So those courts are special courts because, like our sister said, I can also agree, they deal with what? Special cases. Alright, so by the time we are done with those special courts, we will have concluded the content, the course content for the semester. Now, why did I have to take time to talk about course content? It's so that you can take your time and read ahead. I know those people who only remember this course only when they come to class. Don't let your case be like that. So, we already have your recommended test. The same textbook we used last semester is still what you're going to use. So, you can get Nigerian Legal System by Akintunde Obilade, John O. Aseyin, Introduction to Nigerian Law. We have Osita Ogu, Modern Nigerian Legal System. And last but not the least, Sources of Nigerian Law by Nikki Toby. Yeah, Nikki Toby. So, all these textbooks are really very cheap. I think, like I usually say, maybe 3,000, 4,000, 5,000 you can get. So try as much as possible at least get one or two. That's quite below what you spend on data subscription for a week. Right? Go and get. And again, some of you, the phones that you are using, can even buy the company that is producing the book, and yet you will not still have. Alright, so it's important that you get those textbooks and start reading ahead of the class, so that when we come to class like this, I noticed while I was talking, some people were already saying what I wanted to say. Probably they've read it before, probably they've listened to the record, recorded lecture or something. It makes you know better. And that was where we started this class from. So, I do not want to come to teach this course next session and I'm seeing anybody here in that class. It is beyond God forbid. Okay? What did I say? It's beyond God forbid. You need to walk. You need to read, study, and then prepare for your exam. So, with that, we will bring this class to a close. Where is my attendance? Isaac, where is my attendance?